having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, thank you very much and good morning. This is case number 2021-0601, row number 118276 versus the Sex Offender Registry Board. Just a couple preliminaries before we begin. The first is I'll introduce the panel to you. My name is Ariane Vuono. We're joined today with Justice Peter Rubin and Justice Maureen Walsh. I know that both of you have argued many times before the appeals court, and I know that both of you have also participated in virtual arguments as we are today. So I'm only going to say to you that if we have any technical difficulties, just be patient. We generally resolve them quite quickly as we have in the past. You each have 15 minutes and there's no rebuttal. So I'm going to go ahead and start with you, Attorney Green, and hear your argument.
Thank you. Good morning. May it please the court. I'm Ashley Green here before you today representing Mr. Rowe 118276. As the court is well aware, this is an appeal of a level 2 classification, deeming my client a moderate risk offender based on an offense that occurred 25 years ago in 1997. My client had no prior or subsequent sex offenses on his record. He has now been out in the community for 6 years consecutively, but I think it's important to realize that at the time the offense occurred, my client was out in the community for a total of 6 years afterwards. So he does have a large span of time where he's been in the community sex offense free. There are a number of errors that occurred in the hearing examiner's decision. The culmination of those errors is what's going to lead me to ask this court for a reversal of the decision and a remand back to the board or a reduction in his level. The first argument that I would like to start with is that the hearing examiner applied 7 risk factors to my client's case, assessing him as a level 2 without giving us any indication of the amount of weight that was assigned to each of those factors, whether it was a threshold, moderate, or high full weight. The blanket application of these factors puts us in a position to not know what the hearing examiner was thinking to reach this conclusion. In a case where the evidence is overwhelming that a former offender would be required to register as a level 2, this may not matter as much. However, in a case such as this one, where it has been 25 years since my client sexually offended, and the board's power is to classify someone based on their risk to reoffend sexually, these factors matter. Every factor matters. Every ounce of weight matters. And while this court might believe or feel, based on the case law, that the discretion lies with the hearing examiner, that discretion cannot go unchecked. Here,
Can I ask you a question, if I may, Attorney Green? Would you agree that by citing these factors, that the hearing officer, at a minimum, said the factors apply, right? That there's just some, at least to a certain degree.
yes.
Okay.
Yes.
So, what if we were to presume that it's just the minimum amount of weight? Where does that lead you in terms of your argument?
In this case, and you have to take each case individually, obviously, in this case, because there are no high risk factors that apply to my client's case, if we're then to speculate that the hearing examiner only applied the lowest level of weight to the factors that were applied, my argument is that that does not reach the clear and convincing evidence standard that my client is a moderate risk to reoffend. Because if you're looking at all of the factors, there's a substantial amount of mitigating risk factors that are applied. And those are current factors. Now we're looking at the current level of risk. So if the hearing examiner is taking, let's take, for example, factor 7, factor 8, factor 18, factor 19, those were some of the factors applied with no weight. Those factors all directly correlate to the offending behavior in 1997. If the hearing examiner is applying full weight to those, or even arguably moderate weight to those, that is an error. That is an abuse of discretion, because the hearing examiner is applying factors that, yes, the scientific research might say that those factors apply and they raise the risk. But if something occurred 25 years ago, and we have a hearing examiner that's still giving a substantial amount of weight to those factors, that's an error, period. That's an abuse of discretion.
Let me interrupt for a moment, Attorney Green. If I understand your argument correctly, the age of the sexual offense should be the determining factor, whether it's a low, moderate, or substantial weight given to the factor.
I don't think that it's that directly correlated. I do think it should be a sliding scale of factors that are static factors that occurred at the offending date. As the decades go on, I submit that their weight should be reduced, because that is what the scientific research says, is that based on the offending behavior, let's take, for example, factor 19, level of physical contact. If 5 years ago, somebody committed a horrendous sexual offense where there was a high level of physical contact, that may receive full weight, and the scientific research supports that. However, if it has been 25 years since there was an incident where there was a high level of physical contact, and we now have a hearing examiner giving that factor full weight, that is an error. That is an abuse of discretion.
Let me ask you this then, Attorney Green. Aren't there certain factors that already consider both the individual's age, presumably from the time of offense? So as they get older, their risk is reduced. So that's already factored in. But there are certain factors that just are not dynamic. They're static factors. For example, the violence used. It may always be a high, but there are other factors, because there are numerous factors that a hearing examiner considers when designating what level of risk to the public that this individual is. So do you accept that there are certain factors that just, because of the nature of the offense, for example, may always be high, but there are other ones that are dynamic? It's a combination of static and dynamic factors.
I submit that the factors that are static should be given less weight the further we get away from the offending behavior, because that risk is no longer prevalent in that offender's life, in their lifestyle and their behavior. So something that somebody did 25 years ago might not be within their person anymore to be able to commit those types of behaviors, but we're still giving it full weight. And so the atrociousness, if I will, of the offending behavior, yes, it existed at one time, and that person would be a high risk offender based on those factors. But the further we get away from it, they can't hold the same weight, because the problem is these former offenders are not given enough of these dynamic factors that are mitigating and reducing their risk to get their level down. So they are getting.
I'm trying to figure out what you're arguing here exactly. The regulations don't currently, unless I'm mistaken, don't currently say anything like this. And obviously there are times when the regulations have been found inadequate, either because there is new science that indicates that they don't reflect accurately on risk assessment, or because the Constitution says that can't be a way that we assess it. Are you making an argument like like that. I mean, I'm sympathetic. I just don't know what avenue we have to say, oh, yeah. I mean, unless you've got a study that says 25 years ago for this kind of terribly violent sex offense is too long to be treating the static factor the same as if it was 15 years ago, I'm not sure how we're supposed to instantiate the concern that you're describing in a legal rule.
I wish I had that type of scientific data to bring to this court. What I do have is that there is case law saying that these decisions have to be specific and detailed. And just checking off that this factor applies 7 times for risk elevating factors is not specific and detailed enough in a case where it has to be clear and convincing evidence, because we don't know what the hearing examiner based their decision on and how much weight they gave to each factor. And now I will say that in the last year and a half, the hearing examiners have started to do this. But unfortunately, my client's case is from a couple years ago and they weren't doing it. And that's why I'm asking this court to remand it back for the hearing examiner to give a specific and detailed decision so that this court can decide whether they abuse their discretion or not.
When you say doing this, you mean giving a more sort of discursive analysis rather than what is the this that they're now doing that you think they weren't doing before?
They are now giving factor weight to each factor.
I mean, I just by saying I give it medium weight, I give it full weight, I give it little weight.
Yes, because if they are giving full weight to something that clearly in the evidence does not support full weight, on appeal, my clients are able to have a just decision and an actual review of the hearing examiner's decision.
Well, again, can you tell us which factor then you think, you've indicated on factor number 8, for example, talking about physical violence, is one where you said that given the passage of time, there's no support for full weight, right? Is that your point?
Yes.
Okay. So you would say the exact same thing about number 7, for example, when the victim and the defendant are strangers, that there's just because it was over 2 decades ago, you're saying that factor could not be given full weight.
Correct.
And where do we look to say that that's an abuse of discretion by giving that full weight? I mean, those facts have not changed. So the fact that they were, it was a stranger.
So in hearing examiner's decisions, sometimes they'll include language like the datedness of this risk factor lessen the risk elevating weight. If that makes sense. So they will acknowledge. I've been getting.
It's back to actually the original question that Judge Walsh asked you, which is, although there are other factors, mitigating factors that take into consideration the length of time that's passed since the event occurred, the fact that now a petitioner may now have health problems, a petitioner now is older, all of those things that are considered that take in terms of passage of time, and with those factors, that's where you're saying that that's not sufficient, that these static factors have to be addressed specifically.
Yes, and just to go back to what you were saying, you stated that the passage of time since the offending behavior is taken into account. That's actually not something that's taken into account, which is very problematic. One thing that's taken into account.
What I meant by that was, let me be clear. Let me be clear. What I mean by that is what is taken into account is the following: the age of the petitioner since the event occurred. So that is an aspect of passage of time. Development of illnesses potentially that would mitigate any issues. That's a passage of time issue. So that's what I mean by that. I don't mean there's a specific factor that talks about that. So that's just to be clear.
Can I ask a question? Maybe you've actually clarified this, I'm not sure. Do you sometimes get decisions from SORB where the hearing examiner says, because the offense was 25 years ago, I give less weight to this factor.
Yes.
Hmm.
They use the term, I've noticed, datedness. Given the datedness of this occurrence or this behavior or this information, I give it less weight.
I mean, I have to say, and
That'll work.
Attorney Shania knows, may remember that I mean, I can't stand the apparent arbitrariness of this whole scheme. And if some people are getting the benefit of datedness and others aren't, it doesn't seem like a uniform system very well, but we'll ask him about that as well.
And that's why I bring this specific case to your attention, because the datedness is such an apparent thing. It is an isolated incident. It's a one-time offense.
Well, it's a
25 years ago.
serious, okay.
I would like to move on to actually my third argument next, if that's okay, and that is regarding
pretty quickly, because your time is just about up. Your time is actually.
just to factor 11, another glaring example of an error and abuse of discretion. Factor 11 was applied as an aggravating factor. That is not, it should not have been applied in this case. This was a 2001 police report from Mr. Rowe's then girlfriend, mother of his children. It was dismissed. She is fully supportive of him. She wrote letters on his behalf. Should not have been applied.
All right, you made that clear in your brief, so we have your brief. Thank you very much.
Thank you.
Attorney Shania?
If it pleases the court, David Shania for the board. This is actually a case kind of shows how the system is, or the scheme is supposed to work. The individual had a number of static factors, were high risk with his sex offending behavior, but the hearing examiner took into account his current age, his current stability in the community, and his current support network, and reduced the high risk of those static factors to a moderate level. So there was a reduction for time-related events that occurred. And I think looking at the application of the factors that were non-static, the criminal record and factor 11, the non-sexual violence, I think out of the two, the non-sexual violence is probably the weakest part of the hearing examiner's decision. The board's position is that it's, judging from all the other evidence, it's harmless error. And I think I addressed that in my brief. I can pretty much rest on my brief unless the court has specific questions regarding either the factoring or the hearing examiner's decision.
So can you respond to the observation that Attorney Green made before, that sometimes hearing examiners will say that something is dated and give less weight to a factor and sometimes not?
You know, I have to say, I probably read way more hearing examiners' decisions than I would like to have to read, but I have not seen it with static factors. I've seen it with criminal record, incarceration history, probation history. I've yet to see it with a static factor. I'm not saying that hasn't happened. If it has happened, the hearing examiner misapplied that factor to the benefit of the individual of that time, because the hearing examiner is not supposed to give moderate or less weight to the static factors, which are the sex offending behavior. So 496-501 made it clear it's important to consider the past sex offending behavior to get a holistic view of the offender, being that those factors are high risk factors. And it's from that point, and again, I think Justice Walsh hit the nail on the head. It's the time that can diminish the impact of those factors, the intervening events. Like in this case, if this individual hadn't been in trouble since his release from incarceration, we may have been looking even a little bit more help on his end. But the problem is he has 2 years incarceration in 2014, and out of the 19 years from the time he was sentenced, he has spent 13 years of those incarcerated. So he can't get the benefit of offense-free time in the community. But still, the hearing examiner did credit him for his support network, current support network, and the stability that he's established in the community in the last 6 years, or last 4 years since actually the cocaine incident. So I think, again, to answer the question, I haven't seen it yet with static factors. And if I did see it, I would notify my office immediately that the hearing examiner is erred in that area. That would be my analysis of that argument. So again, I'd be more than happy to rest on my brief at this point.
I'll inquire if the panel has any further questions of you, and I'm seeing none. You may rest on your brief. Thank you both very much for your arguments. We'll take the case under advisement and we'll get an answer to you as soon as we can.
Thank you, Your Honors.
Thank you.